Hello. I would like to welcome and thank everyone for taking a moment to join us for today's Meritas Capability Webinar, Global Immigration Solutions for Multinational Businesses, How Meritas Can Help. My name is Crystal Dahl, and I'm the Online Communications Specialist for Meritas. Today's webinar will be presented by 5 Meritas members coming from various markets across the globe. We have Bruce Harwood presenting from our Vancouver, Canada affiliate, Boughton Law Corporation, Ted Kelleher and Mike Murray from our Portland, Maine U.S. affiliate, Drummond Woodsum, and also Gerald Santucci and Nick Tebby from our Meritas affiliate, Snedden Hall Gallop Lawyers in Canberra, Australia. Now before we get started, I would like to go over a few housekeeping items. As many of you have likely noticed, all telephone lines have been muted. If you have a question for any one of the presenters, you are welcome to ask via the chat feature found on the left-hand side of your screen. They will plan to answer your questions at the end of the presentation. If you experience any technical difficulties, please press *0 at any time to connect with a support technician. With that, Ted, are you ready to get started?
Yes, I am. Thanks, Crystal.
You're welcome.
Just a couple words about how we are organizing our presentation today. Our goal today is to help our listeners understand how multinational clients can use the immigration systems of our respective countries effectively when they are moving key personnel around the globe. We're trying to give a broad strategic picture here. Anyone who has ever dealt with immigration matters understands how complex and detail-driven these processes can be, and we don't want to get too bogged down in the minutia. And plus our time is limited, so we want to use it effectively. So for each of the U.S., Canada, and Australia, we will start with a very basic and broad overview of how immigration cases get processed by our respective governments. Then we will each discuss the key business visas that your multinational clients will utilize, highlighting the major features of each relevant visa category. And finally, at the end, we want to say just a few words about why we think using Meritas affiliates for these immigration matters is a really good value proposition for your clients. And with that, I will turn it over to my colleague, Mike Murray, to talk about the U.S. immigration system.
Thank you, Ted. Okay, so when you get that call from your client asking for assistance with getting a key employee into the United States, your first goal is to make sure that the right visa plan is in place. And your second goal is to make sure that the employee is prepared for that meeting with the mean, grumpy immigration airport officer who will ultimately be deciding whether or not your client, your employee, is going to make it into the U.S. for their purpose. I think Gerald and Bruce can confirm the fact that the grumpy airport officer is kind of a universal phenomenon in immigration law. Now, just about any visit to the United States is going to require some kind of pre-clearance. And certainly, if you're going to be sending an employee to the United States to actually perform work or to do a work project, that has to be preceded by filing for and obtaining a work visa or work permit. And we're going to talk about that process here in a bit. The agencies you'd work with in the United States are the Department of Homeland Security. That's kind of the broad immigration function in the U.S. They will process and issue immigration benefits. They staff the grumpy airport officers in customs, and they also enforce our immigration laws against those who would overstay a visa or those who enter the United States illegally. The State Department governs U.S. embassies and consulates overseas, and that is the agency that will issue travel visas and work visas into passports, which allow for nationals to arrive at our doorstep and ask for entry in a certain visa category. And lastly, there's the Department of Labor, which is an agency that's kind of more behind the scenes. They will take a part in certain immigration or visa cases in terms of making sure that the wage paid to foreign workers does not depress the wage of U.S. workers, and in other cases to make sure that before a job is given to a foreign national, that there's a chance for a U.S. worker to get that job. Let's talk a little bit now about the process of how you get a work visa for one of your client employees. Each visa is a little bit different, and you have to take them case by case, but a good way to think about getting this type of visa benefit is in a 3-step process. The first step is known as the immigration petition, and that's filed with the Department of Homeland Security for a work-type visa that's usually filed on an I-129 petition. That kind of petition, unfortunately, can take 3 to 5 months to process through DHS. However, if you pay what's called, well, it's not my term, but many people call it a legal bribe to DHS in the form of a $1,225 check, you can have your petition upgraded and processed really just in a couple weeks, which is a time frame that's much more friendly to business as we know it. Once you have your petition in hand, your client can then proceed to the embassy to process their visa stamp into their passports. This is usually a pretty quick process these days, maybe 1 to 2 weeks. If you're in a high traffic area in terms of visa processing like India or China or the Philippines or Mexico, you should budget a couple more weeks for that process. With the visa and the immigration petition approval in hand, your employee can then go on to meet with or to have that fateful meeting with the grumpy airport officer. But if we've done our job correctly at this point, things should go very smoothly and all will go well. Now, in terms of budgeting time overall for that 3-step process, as I say, it really varies by visa. It can even vary by nationality of the employee. So you have to check in and look at the timelines that apply. Budgeting several weeks to several months is kind of the shorthand rule. But for example, a Canadian who's applying under the NAFTA treaty for a TN type work visa can process that visa at the border in person. It can even happen in 1 day, depending upon the speed of your typing and the speed of your courier service. So that is kind of the broad outline of how visas get processed in the U.S. As Ted mentioned, U.S. immigration is vast, and we're not going to talk about all the different aspects. What we're going to do is really kind of laser in on the visa tools that will apply to your clients, the ones they're most likely to use to get those key employees into the United States. And here's a quick overview of the ones that I'm going to talk about, and I'm just going to jump right into the first one, which is the business visa, known as the B-1 visa. Before we get to work visas, many companies would like to send their employees to the U.S. for exploratory visits, to meet with business associates, to research investment opportunities, and the B-1 business visa is the tool you would use for that. You can see there along the left a list of the acceptable activities that can be undertaken on this kind of visa, and immigration is very keen on making sure that the scope of activities are fit right into that box. The big ticket item here is that immigration does not want a business visa to be used in lieu of a work visa. That is a big no-no. And in order to make sure that your clients avoid that, you want to look at these no-nos along the right-hand side. These visits really have to be short-term, usually just a couple of weeks. If you can justify the business need, sometimes you can get a stay of a couple of months, but you have to have documentation to show exactly what type of activity is going to be undertaken. Work of any kind, whether for a U.S. employer or a foreign employer, is simply not allowed. There are some esoteric exceptions to that, but we won't go into that. Receiving salary from U.S. source is not allowed. The payment of expenses or reimbursement for travel is okay. The key to success for a B-1 visa usually is a business invitation letter provided by the U.S. partner company in conjunction with some counseling for the employee who intends to travel to the United States. It's really important to give them a heads up about the limitations on the scope of their activities. For example, the uncoached employee may use loose terms like, working on a project or doing a little work in the United States when they're at their meeting with the airport officer. Those are loose terms that have a certain meaning for the individual, but a very different meaning for the airport officer. So a little bit of counseling goes a long way in this context. Now, there is one free lunch when it comes to U.S. immigration, and it's just about the only free lunch, and it's called the Visa Waiver Program. And this program is meant to facilitate ease of travel, entry and exit for international business visitors into the United States. So if you qualify for this program, the employee does not have to get a visa stamp from the consulate. They can go straight to the airport and travel to the United States. There are some limitations here, of course, as ever. This program is limited to those nationals from the countries listed there on the chart that you see. And those individuals have to have what I would call a smart passport, a machine-readable or biometric passport that can be read by the U.S. immigration databases. Most recent visas will qualify for that, but you certainly have to check those items before you let your employee take off to the United States for a business meeting. Now, even though some employees will use the visa waiver program, you have to make sure that all the elements are in place for a good business visit, the short-term stay, the business invitation letter, and a little bit of preparation and counseling for the employee before they take off. Now let's get into our first work visa, U.S. work visa, and this is known as the L1A or L1B work visa under the Intracompany Transferee program. This is a key tool for global businesses and is really set up especially for global companies that have a foreign office and a U.S. office. There are a couple of requirements that have to be satisfied. Those two offices have to be under some form of common ownership, and it's reserved for employees who are either at an executive, managerial, or specialized knowledge capacity. And the immigration regulations have pretty specific definitions for how to qualify under those categories. The executive or manager can spend up to 7 years in the United States on this type of visa, and the specialized knowledge employee can spend 5 years. Specialized knowledge is certainly a term of art in immigration law. There are many different interpretations of it, but basically it means that kind of employee who has a very deep or advanced knowledge of proprietary technology or procedures for the company. And in any of these cases, those employees who qualify have to have been employed abroad by the foreign entity for at least 1 year. Now that's what the regulations say, but it would be wise to, if you're choosing a candidate to transfer to the United States for a certain project, if you can choose an employee who has more than 1 year, let's say 3+ years of experience, that's going to be a much better candidate for this kind of program. This category overall, the L1 program, although it's probably the best tool for multinational companies, has really been under fire for the past 5+ years. There have been certain bad actors who have kind of spoiled the pot for everyone. And these days, even though it's a great program, you really need expert advice to get through the petition process and the visa process successfully. So make sure you get all your ducks in a row if you're going to use this program. Now I'll move on to what's known as the H-1B visa, the professional visa. If your employee does not qualify under the Intracompany Transferee program, the most likely fallback option that you'll use is the H-1B. This is in some ways kind of a catch-all visa category. It's very flexible, and any position that is professional in nature, the legal term is a specialty occupation, will qualify. This basically means that the industry standard for that position is at least a college degree, a 4-year bachelor's degree for hire. We all kind of have a rough idea of what these positions are: engineering positions, high-level executives, computer programmers, researchers, and so forth. Now, the second part of this equation that sometimes people forget is to make sure that the foreign national employee who's applying also has the requisite and closely matched background. So that an engineer would have to have a degree in engineering, for example. Now, although the H-1B is oft used and very flexible, there's a big gotcha when it comes to using H-1Bs. They're really too popular, and the demand outstrips the supply every year. Our beloved U.S. Congress, unfortunately, you may be shocked to know, hasn't really kept up with its work and hasn't raised the annual limit of H-1Bs, and in fact has suppressed them for the past several years, so that the annual allotment is now 65,000 with an extra 20,000 for foreign nationals who hold U.S. master's degrees. As I say, this is never enough, and what happens is that there's usually a long wait to get an H-1B, sometimes a year or more. The new crop of H-1Bs become available at the beginning of our government fiscal year, which is April 1, and they usually run out on that very day or a couple days thereafter. At least that's happened for the past few years. So the thing to know is that you have to file in advance and plan in advance if the H-1B is the only work visa that works for your specific employee and project. And making that filing on April 1 is a key goal. The other thing to keep in mind for employers is that there is a prevailing wage requirement that applies to the H-1B category. It does not apply in the L-1 context. And that basically means that the Department of Labor will take a part here and make sure that the wage to be paid is roughly the average wage for that kind of work in the area of employment. And the H-1B visa can be had for a 6-year term of stay in increments of 3 years each for your foreign employee. And finally, if those categories don't work for you, I'll talk about just 2 other potential U.S. visas. These are a little more exotic, a little more unique, and may not apply in all cases, but can sometimes be very helpful. The first is the E1 or E2 Treaty Trader or Treaty Investor visa. These are visas for foreign companies who do substantial trade and predominantly trade between the home country and the United States, or a foreign company that's made a substantial investment in a U.S. business. 2 big gotchas when you do an e-visa, when you're trying to set up this type of e-visa plan. First, you have to make sure that there's a bilateral treaty of commerce between the home country and the United States. Many immigration lawyers have been shocked by the fact, after a few weeks of preparation on an E-1 visa, to find out that the requisite treaty was not in place. So that's something you have to look at on the front end. The other limitation is that the visa applicant, the employee who's going to be sponsored for the visa, has to share a nationality with the sponsoring foreign company. So for example, we were processing a visa for a high-level executive at an Italian engineering firm. This was last year. Initially, our plan was to do an e-visa, but we realized that the executive was actually a Spanish national and not an Italian. So we had to reconfigure our plan. We went for the L1 and everything worked fine. But again, that's something you'd want to plan for up front. The e-visa can be conferred for either a 2- or 5-year visa stay in the United States. And finally, I'll talk about the TN or Trade NAFTA visa. This is really a visa benefit for our neighbors here in North America, or for Canadian nationals and Mexicans. This is a great kind of streamlined visa, as I mentioned before, that can be issued sometimes even in a day. It is reserved roughly for professional positions, engineers, management consultants, and you do have to have a foreign national employee with a requisite professional background that matches. There's something called the TN schedule that breaks down all of the different types of positions and the requirements that are necessary for qualifying for that visa. And these visas can be issued for up to a 3-year stay. So that is my brief tour, my quick tour through U.S. immigration visas. I just want to say that Ted and I would be very happy to be your experts on the ground for getting your key employees to the United States. And with that, I will turn it over to Gerald in Canberra.
Thank you, Mike, and good morning. And I say good morning because it's 6:19 a.m. here in sunny and warm Canberra, the capital of Australia. I have to reiterate the point that Mike made about the grumpy airport immigration officer. And the job of any migration agent is to make sure that when you're landing in a foreign country, that passage through the airport immigration officer is as smooth as possible. So broadly, what we're going to talk about this morning from Australia's perspective is a quick, short historical view of our system, the difference between temporary and permanent visas, and then the temporary work options, short, long-term, the rights of workers, obligations of sponsoring employees, and then very quickly some permanent work options. So Australia's migration regulations currently operate on the basis of the 1958 Act, with migration regulations which run the operative side of the system. And they were last amended in 1994 in a wholesale fashion, but there's constant revision every few weeks from the Department of Immigration and Border Protection, as it's now called. Anyone visiting Australia who's not a citizen has to hold a visa. And there are over 100 different types of visas. And our migration program is focused broadly in the 4 areas of skilled visas, business visas, family visas, and protection visas, which often referred to as refugee visas. Visas are separated into classes and subclasses with specific criteria attached to each. And when you see the subclass category for criteria for a visa, you must always check to see what the class of that criteria is at the same time. Otherwise, you may miss out on some important aspect of the visa. So we've got temporary visas, permanent visas, and bridging visas. Bridging visas are designed to keep you lawful in Australia while you're making some other application, or indeed if you've breached the migration laws and you're waiting for an appeal or actually to leave the country. The majority of our applications are now submitted online, and there's a heavy focus on what the department calls decision-ready applications, with a high evidentiary burden on the applicant. You must provide all the information that will satisfy the criteria. The department will then make a decision. If they make a decision against you, you may have some rights of review, otherwise you have to start again. The move towards streamlined application processing for certain passport holders seeking to enter Australia for certain types of short-term visas are now known as e-visas. These are non-evidentiary visas in a certain sense because nothing goes into your passport, although the department will often issue a document reflecting the nature of your visa and its terms and conditions. So we have short-term electronic visas. Our visa subclass system is based on numbers. The class system is based on letters. So we've got a subclass 601, which is an electronic travel authority. It's valid for up to 12 months and permits visits of up to 3 months duration per time. So you can make 3 visits, but you have to leave the country for a short period of time. There's no application form. It's usually granted by purchasing an airline ticket. And again, as it was the experience, or is the experience in the United States, there are certain passport holders only that benefit from this visa, and that includes our dear friends in Canada and the USA, as well as Austria, France, Germany, Japan, UK, and others. But I didn't publish the whole list because it's quite exhaustive. And there's a $20 application fee, which is by far the cheapest application fee for any visa for Australia. Now this permits what's called business visitor activities. So they're general business or employment inquiries, investigating, negotiating and entering into contracts, participation in a conference, trade fair, seminar, unless the person is paid for that participation. But you're not able to undertake work for or supply services to an Australian organisation or person in Australia, and you can't use it to sell goods. We also have a subclass 651E visitor visa, which is very similar to the 601. However, and for reasons which we don't understand, it's not available to citizens of the USA, Canada or Japan. It does include the European countries mentioned before. But again, it's up to 12 months, 3-month visits at a time, no paper application, but there's no application fee. They clearly want to get some money out of the Canadians and the US citizens. It also permits business visitor activities, and similar to the other visa, it allows investigation, negotiation, entering into contracts, participation in trade fairs, and again, you're not permitted to supply services or undertake work for an organisation or sell goods. Now, we then move to a relatively new category of visa, which is the subclass 400 temporary work short stay visa. And this allows a person to enter Australia to undertake highly specialised but non-ongoing work or participate in non-ongoing events as an invited participant or participate in activities judged to be in Australia's interest. Now, these are only up to 3 months. You can bring your family members. You can work. I withdraw that. the work or activity must be non-ongoing, so you must finish it within 3 months. You must be able to support yourselves, so there's no need for a sponsor, but you must also show that an Australian employer or Australian organisation has invited you, and usually that can be done by way of a letter on letterhead. And there's no study in Australia, and there's no renewal or extension. So we've got a subclass 401, which is a long stay visa, and this allows a person to enter into Australia in one of 4 streams. So you've got the sports stream. So when Tiger Woods comes to play in Australia, he can just get a 401 visa. An exchange, religious workers or domestic workers who are employed by certain 457 senior executives, which is a 4-year long stay visa, which I'll talk about in a moment. This has up to 2 years validity. It can be extended onshore. You may bring your family members, but you must be nominated by an organisation or institution which is approved as a sponsor by the Department of Immigration. And you must have the skills necessary to undertake the work. So now we turn to what's often called Australia's favourite temporary visa, which is the subclass 457 temporary work visa for skilled people. This allows a person to enter Australia to work in a skilled position. It has 4 years validity. You can bring family members. You must be nominated by a business which is approved as a sponsor by the Department of Immigration. The sponsors may be either operating a business in Australia, that is an Australian business, or a business which doesn't yet operate inside Australia, but which seeks to send employees to Australia to establish or assist in the establishment of business operations in Australia or to fulfil a contractual obligation of the sponsor. So you must have English language abilities, you must have the skills necessary to undertake the work, and you must meet certain health and character requirements. Depending on the country from which you originate, those health requirements may be a full health check or just a short x-ray. It must be a genuine, skilled and position, and it must be paid at a minimum salary. I won't go into the details about salaries because they're quite complex. But these are very popular visas as a way of bringing people out to Australia. Now, those people who are on that visa are entitled to all of the benefits of industrial relations protections. Indeed, it's an offence by the employer not to arrange workplace safety, the award wages, as if these people are Australian citizens. We also enforce visa conditions. No study. There's a limitation on study. There's a limitation on work in the extent that you can only work for the employer who has sponsored you and for the position for which that employer has nominated you. And there's also a limitation, there may be a limitation, on future onshore applications. Usually a 457 allows you to apply for permanent residency after a period of time, but in certain visas you may not be able to apply for any other visa onshore. You'll have to leave Australia and then you can apply. So the conditions vary from subclass to subclass, and understanding the effect and application of conditions is essential. The visa conditions can be waived or varied, but only in very limited situations. Now briefly, some information on permanent visa options. A permanent visa allows you to come to Australia and travel to Australia and live here for up to 5 years. But it's important to note that although the visa is permanent, you must obtain a resident return visa if you are about to leave Australia and the 5-year period is about to go up to expire. Otherwise, you won't be allowed back in the country without another resident return visa. That's the first thing to note. Having said that, permanent residency visas are allowed for employers who have employed people, for example, on a 457 visa for up for 2 years or more, or for people who come in as a direct entry. The employer has to lodge a nomination, which has to be approved before that employer can employ the applicant. It has to be a skilled position, has to be paid market salary, must be available for at least 3 years, and requires a contract of employment. Again, the employee must demonstrate English abilities, skills, as well as meet health and character requirements. And the health requirements here are full health requirement. It's important to note that this is only available for employees of an Australian business. So the foreign business should use initially the 457 visa to send someone to Australia. Employee must, so then we also have what's called a regional sponsored migration scheme, which is similar to the employer nomination scheme mentioned above, but there's more relaxed criteria because it's designed to encourage people to undertake employment in regional Australia. So these visas are points-tested visas for skilled individuals. You may seek nomination from a state or territory government. In certain cases, there's no link to the employer, but all applicants still have to meet the basic age, English language, skill education, work experience, and health criteria. And they have to submit an expression of interest online and then wait for an invitation to apply. Now, if you are seeking territory or state government sponsorship, once that's been approved, the government will ask the department to send an invitation to you to apply, and that's a pretty smooth process. Finally, then, we just want to talk about those business skill visas are a two-stage process. So we talk about a permanent visa option, but initially it's a provisional visa, and it only qualifies you for a permanent visa if you meet certain requirements while you hold the provisional visa. It's for people who want to own and manage a new or existing business in Australia or to invest in an Australian state or territory. And there are three streams. The business innovation stream, for people with business skills who want to establish, develop and manage a new business in Australia or an existing business. There's an investor stream, for people who want to make a designated investment of at least $1.5 million in an Australian state or territory and maintain a business and investment activity. Or for people who are willing to invest at least $5 million Australian dollars into complying investments and want to maintain business and investment activities in Australia. So that's as quick summary as I can in relation to our business categories, temporary and permanent. I'm delighted to take any further questions from you either now or later on, and I'm delighted also to hand over to my Canadian confrere Bruce to tell us all about the Canadian requirements. Thank you, Bruce.
Thanks, Gerald. Grumpy is a nice term, and we have several other terms for border officers here at the office, which I can't go into. First of all, if there are questions remaining after I finish with this presentation, please do not hesitate to email me directly at bharwood@boughtonlaw.com. My focus is somewhat more narrow than the two previous presenters in that I'm going to focus on one type of work permit, which is the Intercompany Transferee work permit. But I'm going to start with an outline to put the Intercompany Transferee work permit into the context of Canadian immigration law. As you're going to see, the Intercompany Transferee work permit for international business is a very handy tool given some of the difficulties or obstructions that are in place legislatively for bringing foreign workers into Canada. So the first basic rule is that Canadian citizens have an absolute right of entry to Canada. Once a person who approaches a port of entry demonstrates Canadian citizenship, any examination of them ends and they must be admitted. Entry for permanent residence is qualified by such matters as the commission or conviction of a criminal offense, a breach of terms and conditions under which the permanent resident was admitted, a determination of misrepresentation or fraudulent or improper means in acquiring permanent resident status, and most commonly, the failure to maintain 730 days of physical residence in Canada in any 5-year period. These factors may lead to loss of permanent residence. On the other hand, temporary residents, workers, students, and visitors have no right of entry. They must ultimately satisfy an officer at a port of entry that they are entering for a temporary purpose as a worker, student, or visitor, and will leave Canada at the end of their stay. Workers and students are normally documented on permits as distinct from visas. Under Canadian law, Visas are scanned impressions placed into the passport. Permits are physical documents normally issued at the port of entry, sometimes by the visa office, which are stapled into the passport. Visitors are also documented on what are called visitor records when the officer determines there is a need to control their length of stay. If an officer does not issue a document controlling length of stay, then any visitor to Canada has an automatic 6 months entry. In addition to the issue of admission on as a temporary worker, student, or visitor, certain foreign nationals are required to obtain a temporary resident visa, regardless of the purpose for seeking entry. Not unlike the U.S. waiver program, there is a specific list of countries that are exempt from the temporary resident visa under Section 190 of the Immigration and Refugee Protection Regulations. In general terms, that includes nationals of Western European countries, Australia, New Zealand, Singapore, Japan, South Korea, and of course the United States, to name just a few. This list is subject to amendment, and for example, in June 2009, nationals of Mexico were removed from the exempt list, and now, despite the fact that they are partners in the North American Free Trade Agreement, they need a temporary resident visa regardless of whether or not they are eligible for a work permit under NAFTA. For visas, you apply at a diplomatic post outside of Canada as required. Now we're going to turn to the entry of foreign workers in general and intercompany transferees in particular. In terms of the general process, unless an exemption applies, there are 3 steps required to hire a foreign national. The first step demands that the employer apply to Service Canada, commonly referred to as Human Resources and Skills Development Canada, or HRSDC, which is basically our version of the Department of Labor, for validation of the offer of employment. If the employment offer is validated, a labor market opinion will be issued. The foreign national then applies for the work permit attaching the LMO. Now, what are the LMO issuance criteria? Well, HRSDC will examine the following factors. Generally, they'll ask whether the issuance of an LMO will have a neutral or positive effect on the labor market. More specifically, they will ask certain questions regarding whether or not the importation of a foreign worker will lead to job creation, whether it will lead to the transfer of skills and knowledge, whether it will alleviate a labor shortage. They will also ask whether wages that are offered are consistent with the prevailing wage rate for the occupation in a particular geographical area. So for example, if they were applying for a work permit to work in the Greater Vancouver area, there are specific labor market information statistics on, by occupation, on what is considered the prevailing wage rate for that occupation in the southwest corner of British Columbia. Another factor that they will look at is whether the employer has made reasonable efforts to hire or train Canadians or permanent residents. If the LMO is issued, the next step is obtaining a work permit. But I'm going to caution you that the LMO process is challenging, and the use of lawful exemptions from the LMO is recommended where possible, and one of those lawful exemptions is the Intercompany Transferee Work Permit. Now, usually when an LMO is issued, the work permit follows. Previously, work permits were denied by immigration authorities if the worker had worked without authorization or if the visa office determined that the foreign national was not qualified for the job that had been approved by HRSDC. That is still the case, but now there are other amendments to the regulations that have been placed in the way of Canadian-based employers bringing in foreign workers. And those obstacles include a 4-year cap on work permits, although there are certain exceptions to that rule. There is now a consideration as to the genuineness of the offer of employment, and that genuineness of the offer may be challenged by either HRSDC or the Immigration Department. Employers may also be asked to demonstrate that in the 2-year period prior to seeking a labor market opinion, all foreign workers in its employ are receiving wages and working conditions that are substantially the same as those set out in the current offer of employment. And the significance of that is that if they make a negative determination, HRSDC will advise immigration, and what will happen is a foreign worker will not be able to be employed by the foreign employer for a period of 2 years. So these are considerations that anyone looking at our labor market opinion process should be aware of. Now we're going to turn to the exemptions from this LMO process. And the exemptions from the process are really factored into 2 specific regulations. One exemption is by reason of an international agreement, such as the North American Free Trade Agreement under Immigration Regulation 204. Canada also has free trade agreements with Chile, Colombia, and Peru. And secondly, by a determination that the employment of the foreign national will create a benefit for Canadians, either socially, culturally, or economically, under Regulation 205. It is the intercompany transferee is the product of those 2 main LMO exemptions. Although there are others, but we don't have a significant amount of time today, so we're going to have to leave that alone. Excuse me. In terms of practice points, if the business is bringing in a U.S., Mexican, Chilean, or Peruvian national, use the free trade agreements if at all possible. If it is not possible to use a free trade agreement because you're dealing with a national of another country, use the significant benefits clause of the Immigration and Refugee Protection Regulations, because that does include, to repeat, the intercompany transferee provisions. The qualifying criteria, whether under NAFTA or under the general immigration requirements in the Immigration and Refugee Protection Act, which is the main body of Canada's legislation, are identical. Now, the qualifying criteria for an intercompany transferee are, not surprisingly, quite parallel to the U.S. Requirements. The foreign national must be employed by a multinational corporation outside of Canada. The foreign national must be seeking entry to work in a parent, subsidiary, branch, or affiliate of the multinational corporation. The foreign national must be undertaking employment at a legitimate and continuing establishment of that company in Canada. The foreign national must be transferred to a position in an executive, senior managerial, or specialized knowledge capacity. In addition, the transferee must be coming to Canada for a temporary period of time only. However, that does not preclude the holder of a work permit from seeking permanent residence due to the concept of dual intent, which was placed into our immigration legislation in 2002. So dual intent does not preclude individuals who may ultimately seek permanent residence from acquiring temporary residence status. Furthermore, the transferee must comply with all other immigration requirements, such as obtaining a TRV, which I previously mentioned, and if necessary, passing criminal and security checks. Now, in certain circumstances, foreign workers will also be required to undertake medical examinations, depending on whether their country has been designated as a health risk by the Minister of Health, or if they are being assigned to a particular position in, say, the restaurant industry or the medical profession. So there are additional requirements beyond obtaining the work permit. The work permit will be held until the visa officer is satisfied that the medical has been passed, if necessary, and that the criminal and security checks are also passed. Now, the initial period of stay in the intercompany transferee category is a maximum period of 3 years. Executives and senior managers may obtain extensions from within Canada, but the total period of stay may not exceed 7 years. Persons with specialized knowledge may remain in Canada for a maximum of 5 years. But it's important to note that applicants will be credited for documented time periods outside of Canada, such that the full extent of the authorized time is permitted. So if you sent, for example, a U.S. national back to San Francisco from the Vancouver office for a period of 3 or 4 months, that U.S. national would not be penalized, and his total period of time would actually be 5 years and 4 months in the specialized knowledge category, or 7 years if that person is an executive or senior manager. It is also possible for intercompany transferees to transfer to a new entity set up in Canada. Generally, the company must secure physical premises to house the Canadian operation, but it is acceptable, according to the Temporary Foreign Worker Manual, which is published by Citizenship and Immigration Canada, to use the Registered and Records Office, which is normally a law firm, until premises are secured. Transferees to new entities are normally only provided with an initial 1-year work permit, but may apply for extensions up to the 5 or 7 year cap. I will say that I've noticed in the past year that that initial 1-year work permit has been overturned by a couple of visa offices, particularly Sydney, Australia, where they've been giving 2-year work permits, which in my view is far more reasonable in the circumstances. But the general rule is if it's a new office, they're going to give you 1 year. Now, the company who is putting the foreign company that's putting in a Canadian subsidiary or branch must demonstrate that it will be large enough to support an executive or management function. If the transferee is a specialized knowledge worker, the company must demonstrate that it will be doing business and that the work will be directed by management personnel. For renewal of that work permit for the transferee, immigration officers are instructed to seek confirmation that the new office has been staffed and has engaged in the continuous provision of goods or services for at least 1 year. The Canadian and foreign companies must have what is called a qualifying relationship, and when we discuss a qualifying relationship, we're examining Canadian and foreign enterprises that are legal entities and that have a parent, subsidiary, branch, or affiliate business relationship. The definitions for the terms enterprise, parent, subsidiary, branch, or affiliate that are set out in the general immigration regulations are adopted from the definitions set out in the North American Free Trade Agreement. Both the foreign and the Canadian companies must be doing business, and by doing business, we mean regularly, systematically, and continuously providing goods and services. Enterprise has a rather broad definition. It means any entity constituted or organized under applicable law, either privately owned or owned by government, and includes any corporation, trust, partnership, sole proprietorship, joint venture, or other association. A key point to remember is that if the operating entity is created in Canada and the employee has received intercompany transferee status, any decision to wind up the foreign entity would block the transferee's ability to continue working in Canada, because if there's no qualifying relationship, there's going to be no extension of the work permit. So one of the solutions, if there is some foresight that the foreign company may be wound up, is to ensure that the employee seeks permanent residence in Canada. Permanent residence in Canada is subject for another day because it is a significant topic with a number of options, but 2 options that may be worth considering are the federal skilled worker class and the provincial nomination category for skilled workers. The provincial nominations arise from the fact that every province in Canada has an agreement with the federal government whereby they may select their own skilled workers. And here in British Columbia, we use the British Columbia Provincial Nomination Program all the time because it really does work well. Now, in terms of executives and managers, the Immigration and Policy Manual for Citizenship and Immigration identifies executives as persons that direct the management of the company or a major component or function of the company or establish the goals and policies of the company. Managers are described as persons who manage the company or a department, subdivision, function, or component of the company. And specialized knowledge workers are persons who have specialized knowledge of the company's products or services and their application in international markets, or have an advanced level of knowledge of the company's processes and procedures. Now, I'm going to wind up my comments by putting on the screen the BC Labour Market Outlook for 2010 and to 2020. And the reason I put that up there is because it is a publication of the Government of British Columbia, as opposed to the federal government, which has ultimate jurisdiction over immigration in Canada. But what it demonstrates is that there are significant shortages of skilled labor, both trades and professionals, particularly in this province, and it's going to get worse. And while there are companies who are trying to secure training programs and attract domestic workers for these programs, they're going to be compelled in the next few years to import foreign workers to fill labor shortages. And therefore, HR departments of international businesses should be aware of the provisions of Canadian immigration law with respect to the transfer of foreign nationals into Canada, particularly here on the West Coast where we operate. And I think at that point I will wrap up my comments and turn it back to my U.S. counterparts.
Thanks, Bruce. This is Ted Kelleher again. Great job, Bruce, and Gerald as well. Those were outstanding presentations on a very dense and complicated set of laws. I certainly hope the foregoing has given everybody, all our listeners, a good sense of our technical expertise on these matters. I want to say just a couple of words about what I view as the value proposition of using a Meritas affiliate for immigration matters. You know, when your client sends a key employee to a foreign country, there's a lot at stake. And when the panicked phone call comes from the border crossing station or from the airport, and something's gone wrong or a border guard is misunderstanding something, it's really critical to have an experienced lawyer in that country who knows how to deal effectively with the immigration personnel. And if your clients, like a lot of multinationals, are sending employees to different jurisdictions on a regular basis, getting the global expertise that you need can be really hard to do. Your client either needs to use a large multinational law firm and pay the really high cost charged by the global legal giants, or they can hire multiple law firms around the globe and try to manage all those engagements on their own. I think that Meritas really effectively solves this problem. Our affiliates are vetted for high quality legal services. We here at Drummond Woodsum have had great experiences with our outbound immigration matters using our Meritas affiliates overseas. And they're only a phone call away. If your client is here in the U.S. and needs to get an employee into Australia, you can call Jerry directly. You can call us here at Drummond Woodsum, and we'll get the ball rolling with engaging Jerry. But I think the point is that the work of finding highly competent and experienced global immigration talent in faraway jurisdictions is solved by the Meritas network. And I think that's really an invaluable thing for harried personnel managers at multinational corporations. And I think the second point I really want to make is that a Meritas firm just simply costs less than a giant global law firm with offices around the planet. And additionally, at least our three firms, we're very committed to using flat fee billing so that your clients can have a high level of predictability about the cost of their immigration matters. We charge flat fees per visa, per employee, so that for budgeting purposes, it's pretty clear to a client how much it's going to cost to get an employee into the U.S. We can quote the fees plus the filing fees, and you know exactly how much you're going to pay. Your client knows how much they're going to pay. So from my perspective, high-quality services, ease of access, and reasonable, predictable pricing, that's the Meritas value proposition for your clients. And I certainly hope that we can work with some of you. We're happy to help. And if there are any questions, Crystal, how do you want to handle taking questions?
It looks like one came in from Jennifer, and I'd be happy to read that, and then whoever wants to take it on, that would be great. She wanted to know, when deciding what visa to apply for, what considerations should employers keep in mind if they are considering later filing an LPR application?
Why don't we take that first from the U.S. perspective?
Okay.
Sure. Yeah, Jennifer. It's a very good question. And Bruce raised the concept of dual intent in Canadian immigration law, and that same concept resides in U.S. immigration law as well. Dual intent means that even though a foreign national enters the United States on a temporary work visa, and that's really what we were talking about today, the H-1Bs, the L-1s, the Es, the TNs, under U.S. law, at the moment they enter, they are supposed to have a very temporary intent to remain in the United States, and then once their project is done, even if it spans a couple of years, their intent should remain to return to their home country upon the completion of the work. A work visa, however, that comes under dual intent actually allows that foreign national to, at the same time, it's a bit of a legal fiction, but at the same time, have an intent to remain in the United States permanently and pursue a work-sponsored or family-sponsored permanent residence, or, as you probably all heard across the world, the U.S. green card. So the classifications, well, if you know up front that your employee or your transfer is going to be a permanent relocation, then you would want to make sure that you are getting a visa plan that does have the dual intent concept applied to it. That would clearly be the H-1B and the L-1 visa under U.S. law. There's something called an O-1 visa that I didn't talk about, but that's for extraordinary ability aliens. Dual intent would work there as well. The E-visa could be a bridge over to permanent status. Dual intent doesn't by statute apply, but there is no impediment to pursuing a green card if someone's on an E-visa. The visas you would avoid would be the TN visa under NAFTA, a J-1 trainee visa, and as I mentioned, the B-1 visitor visa or business visa certainly would not be a good bridge over to a green card. Perhaps I'll let the others take a bite at that as well and not go into more detail. Whoever would like to pick it up, please do so.
All right. It's Gerald Santucci from Australia here, Jennifer. Our regime is slightly different. We don't have that concept of dual intent, but as I mentioned in my presentation, the subclass 457 temporary work visa, which is for up to 4 years, doesn't usually have conditions on it preventing a further application, and it is understood very likely that an employer who is satisfied with the employee may then decide to seek permanent entry for them, nominate them, and and then have an application lodged for them to remain permanently. I think that's all I need to say about that one.
Okay. Jennifer, from a Canadian perspective, it's not so much the nature of the work visa that's being obtained as it is the types of permanent resident applications that can be considered. So there are effectively three for a foreign worker. One, if they have a Canadian spouse or common law partner, they may be sponsored for permanent residence. Secondly, they may apply under the Federal Skilled Worker Program, but that program is very restrictive in that it only allows for 5,000 visas to be issued per year, and only 300 in, I believe it's 29 identified categories. The most effective method, at least from our perspective here in British Columbia, is the use of the provincial nomination program, because it doesn't have caps It doesn't have a point system like the Federal Skilled Worker Program. It doesn't demand English language skills, and nor does it demand specifically by law that the credentials be evaluated of the applicant. So there are different nomination programs in different provinces, but if that person were coming to Vancouver to take a position with a BC-based company, that's what I would use the last category, the provincial nomination. That's all my comments.
Fantastic. Thank you. We did have one other question come in that I know Mike had a chance to address via chat, but I thought just in case other people are also wondering the same thing, I'm going to ask you out loud, okay? It was, how do you determine whether there is a bilateral treaty for the E1, E2 visa?
Yes, the answer there is that there is a list that is maintained by the State Department of the different treaties that are on hand between the U.S. and the related foreign country. I put a link to that list into the chat box there. Perhaps you can access that. It's also wise to go ahead and check in with the the overseas U.S. consulate that'll be processing the e-visa application. First, to make sure that you're updated with their latest procedures, but also to make sure nothing's changed since the last time the State Department list was updated. As I say, this is a tricky part of U.S. immigration law. Ted and I did an intake for a foreign national from Iceland, a prominent businessman there, and our first answer between the two of us was, why not do an e-visa? He fits the profile perfectly, coming to invest substantially in U.S. business, and we just assumed that Iceland seemed to be the kind of country that would have the bilateral treaty between or with the United States. In fact, they do not, and I was surprised to find that out. So checking up front is always important. Now, one other wrinkle there in the law is that e-visas can be either treaty trader or treaty investor visas, and I mentioned that briefly in my presentation. Certain treaties will only ratify either the E1 trader or the E2 investor. So that is another thing that you have to look at very carefully, because some companies will qualify as sponsoring visa companies as a trader, but not as an investor. So you have to go kind of one level deeper to make sure you're on firm footing before you start that up.
Great. Thank you, Mike. I do not see any further questions coming in. So with that, I just want to thank each of our presenters for sharing all this great knowledge with us today. It was a fantastic presentation. I also want to let everybody know that shortly after the presentation, I will distribute a copy of their presentation, a recording of our webinar, as well as each of their contact details. Do not hesitate to reach out to them if you have any questions after the presentation. And then I'd also like to thank each of you for joining today. And with that, I will let everybody go. So thanks again, and have a great rest of your day.
Thank you very much, Crystal.
Thanks.
Bye-bye.
Bye-bye.
Thank you.